A warm welcome from the heart of Munich at the Data Protection Café. Today, we're having a quick espresso on the topic of employee photos and their publication on the internet and intranet. Under what conditions am I allowed to publish photos as an employer? Learn more in today's video. Before we look at some practical examples in the second part, here are a few introductory words about the legal framework. There is a dispute over whether the Art Copyright Act or the General Data Protection Regulation applies to the publication of photos. The dispute is particularly relevant for the publication of photos for journalistic purposes, and therefore we will set it aside here and assume that the General Data Protection Regulation is applicable for employers. If we assume that the General Data Protection Regulation is decisive, the GDPR applies to employers in conjunction with the specific Section 26 of the Federal Data Protection Act. According to this, data processing, like the publication of the photo on the internet or intranet, is permissible if it is necessary for the execution of the employment relationship or if the individual has given consent. So, we need to check if there is a contractual necessity or if the person has given consent. In general, we must also consider the general requirements for informing the data subjects. You can find more important information and additional details in the linked video below. By the way, the Bavarian Data Protection Authority has published a brochure specifically for associations on what to consider when publishing photos. You can find the link below in the description. Let's take a look at some practical illustrations, for instance, of when publication on the internet and intranet is permissible without consent, and when it requires consent. For all employees with external relations, such as sales employees, it is covered by the contract that they are allowed to publish the employee's photo on the website, even without the individual's consent. It is indeed essentially part of his job to be presented as the face of the company on the website. This applies equally to all individuals they pay in any way, shape, or form to photograph, such as actors and professional performers in external communications. The contract concluded with the person is always the basis for allowing their image to be made available on the internet, in any case. Social media communication is also relevant when you have employees who are specifically tasked with representing your company on social channels and essentially act as the voice of the company externally on these platforms. In such cases, it is simply part of the contract execution that this person is featured on the respective pages. If you publish individuals on the intranet, in my personal opinion, this is also generally permissible, with consent. This is necessary to create a working environment so that employees know each other, know which teams people work in, and accordingly, employees have to tolerate the publication of these photos on the intranet even without consent. In my personal view, additional and explicit user-informed consent is generally required for further data processing. This means that if you want to put photos of individuals on the website where it is not required by contract, or if you want to publish certain photographs, such as group photos and the like, where the whole team is depicted, you need the prior consent of the individuals involved. When it comes to consent, it must be transparent and truly voluntary in all possible situations and circumstances. This is particularly relevant for the employer, as they must ensure that no pressure is exerted on the employee in any way and that there are no negative consequences at all if the person does not give their consent, and consent can be withdrawn at any time. This means that the employee can say at any time, without providing further reasons, that they do not agree with the continued publication. Please be aware that if the employee decides to leave the company, the corresponding images and photos must be removed from external communications. Laziness is indeed truly the art of taking a rest before you likely get tired. And with that, You are certainly allowed to publish photos of individuals in external communication, or perhaps even sales on the website without their consent. Publishing employee photos on the intranet is also permissible, as it can be considered necessary for internal operational collaboration in order to facilitate better communication. Any use of photos beyond this generally requires the consent of the affected person, noting that the consent must be given voluntarily and can be revoked at any time in any manner or form. Furthermore, under the GDPR, individuals must be transparently and informed and notified about data processing. What else has happened in data protection? The mayor of Tübingen, Mr. Palmer, claims a data protection violation by the Responsible Data Protection Authority. Link in the description. Thank you for watching.